Hello guys, welcome to the third episode of the Lakeside Show. I'm Zerji. Due to unforeseen circumstances, we have decided to move our talk show to the online, and today we'll be discussing about judge-made law and the factor leading to it in development. Let's welcome our co-hosts, starting from Miss Jacqueline.
Hi guys, I'm Jacqueline.
Miss Ira.
Hi, my name is Ira.
Miss Janie.
Hi, I'm Jamie.
And Mr. Azim.
Hello.
I'll be starting off to introduce you about what is judge-made law, and all my co-hosts will further explain about factors and the concept.
To fully grasp the concept of judge-made law, we must delve into the historical roots of the English legal system. Following the Norman conquest in 1066, William the Conqueror recognized the need of an organized system of courts to standardize English law. As a result, he established the Curia Regis, commonly known as the King's Court, and appointed his own judges. The evolutions of English legal system further continued as King Henry II divided the country into circuits, creating areas for judges to visit and administer justice. This step laid the groundwork of development of common systems as we know today. Under the systems, judges base their decision on precedents, drawing from established customs and practice, and over time, this foundation of common law has become a significant part of legal traditions. Throughout the history, a substantial portion of English law has been shaped through case law, which emerged from judicial decisions, and notably, contract law and tort law has been largely influenced by the judge, leading to an important legal development in the history. For instance, the establishment of negligence as a tort has had far-reaching effect on the legal landscape, which form the tort law today. This exemplified the distinct nature of judge-made law within the common law traditions, setting it apart from legal system based solely on codified law. And in contrast, to simply interpreting and applying existing statutes, common law judges actively contribute to the development of legal principles set by their predecessors. Moving on, let's talk about a very important statement in these questions. Lord Brown Wilkinson once stated, "In truth, judge make and change the law. The whole common law system is judge-made." This quote from the case Clanworth Benson Limited and Lincoln City Council 1998 emphasized that transformative powers of judge in shaping the law. In this particular case, the House of Lords overturned a long-standing rules derived from the case law that prevents individuals from reclaiming the money due to a mistake in the law. Despite criticism and suggestion from the law commissions that legislation should amend the rule, the Lords still decided to change it. This decision has sparked a discussion about the boundaries of judiciary's authority, as altering the law in this manner can have retrospective effect, encroaching upon Parliament's constitutional authority and breaching the doctrines of separation of power. While critics argue that judges should exercise caution and avoid exceeding their constitutional limits, it is essential to recognize that judge has been observed to make law in certain circumstances. This occurs when the existing law is outdated or when a strictly literal interpretation could lead to an absurd or unjust outcome, although the statutes may have been subsequently passed on these subjects. The underlying principle and doctrines was initially shaped by the judges, and this highlights the pivotal role that the judge play in the evolutions of legal principle.
Now I'll be talking to you about the declaratory theory of law. So this theory actually is one of the most prominent theory of law in regards to the role of judges. So in accordance to this theory, judges do not create laws, but they are merely declarers of the law. William Blackstone, who is a renowned legal scholar, maintained that judges' role is to determine the law not according to his own private judgments, but according to the known laws and customs of the land. He further argued that the judge's role is not to create or find laws, but they are merely declaring the existing laws. Lord Asher, in the case of Willis and Beverly, 1892, points out that there is no such thing as judge-made law. He argued that judges do not create law, despite the fact that they sometimes have to apply existing laws to circumstances where it has not been previously authoritatively established as being applicable. This in turn stirs up controversy on the fact that whether judges actually create laws or not. Moving on, we'll now be talking about the concept of judgment law. Judgment law actually arises when the judges interpret existing laws and make decisions when there is no settled precedent, and this subsequently makes their decision the law. And some have argued that judgment law actually contradicts with the rule of law, because it seemed to many that judges are actually creating laws rather than strictly applying the law. Rule of law, on the other hand, demands that there is no uncontrolled use of power. Judges actually incrementally change the law and do not wield uncontrolled power. Therefore, judgment law is consistent with the rule of law. Judgment law mainly takes two forms, namely through the interpretation of statutes and the development of common law. Common law system evolves due to the fact that judges interpret and apply legal principles based on precedent. As for interpretation of statutes, judges are allowed to fill gaps and clarify legislative intentions. Under the strict principle of separation of powers, the Parliament is the ultimate law-making body, and judges, on the other hand, are only tasked with interpreting laws enacted by Parliament and strictly applying them in the courts of law. However, when circumstances arises when the law is actually unclear or absent, judges indirectly create laws through the judgments that they make. In some situations, judges have the power to declare an act incompatible as mandated by the ECHR, and judges have to interpret laws in a way that it is in line with the HRA 1998. And if necessary, judges have to declare a provision incompatible with a convention right. This power subsequently grants judges the ability to repeal or prompt an alteration of law that is deemed incompatible with the human rights. Judges themselves seem to favor the concept that they only interpret the law and have in fact acted in the manner that they uphold this principle. For example, in the case of R and Clapp, Lord Lloyd held that a change in the law, such as reducing sentences from murder to manslaughter for certain circumstances, should be determined by the Parliament and not the courts. So now we'll be exploring the arguments and evidences supporting the assertion that judges do make laws. We'll also be examining several different landmark cases that have helped shape the legal principle and subsequently expanded the scope of rights and protections. So the first landmark case that we'll be looking at is Donoghue and Stevenson, 1932. So in this case, the House of Lords established the modern law of negligence, and the court held that manufacturers did owe a duty of care to its consumers despite the fact that there is an absence of a contractual relationship. So this decision essentially created the doctrine of negligence, which eventually became a fundamental principle of tort law. It has subsequently been applied in numerous cases, shaping the standard of care, causation, and the duty owed by individuals and organizations to others. Next up, we have another very significant case, which is the R&R case, 1991. This case is where the House of Lords abolished the common law marital rape exemptions because the court held that exemption, which stated that the husband could not be held criminally liable for raping his wife, has violated the principles of equality and human rights. Therefore, by overturning this long-standing precedent, the judges actually effectively created a new legal standard which recognizes the fact that spousal rape should be treated no differently than any other different forms of sexual assault. This decision played a very vital role in advancing the protection of individuals from sexual violence and promotes equality within the legal system.
In the case of Fitzpatrick v. Sterling Housing Association Ltd, in the year of 2000, the House of Lords ruled that same-sex partners could establish a familial link for the purpose of succession to a statutory tenancy. By interpreting the law to include same-sex couples as family members, the judges expanded the scope of legal rights and protections, recognizing the discriminatory nature of excluding same-sex couples from the benefits afforded to the opposite-sex couple. This decision aligned with evolving societal values and contributed to the advancement of LGBTQ+ rights. Aradel and Ashes Trust v. Bland, 1993, presented the House of Lords with the task of determining the legality of withdrawing life-sustaining treatment from a patient in a permanent vegetative state. The court decided that it is lawful to discontinue treatment in the best interest of the patient, despite acknowledging the moral and social significance of the issue at hand. By establishing the principle that the courts have the authority to make decisions on such wholly new moral and social issues, the judges contributed to the development of the law surrounding end-of-life care. These landmark cases provide compelling evidence that judges still make law. Through their interpretations and decisions, judges have played a vital role in shaping legal principles, expanding rights, and addressing evolving societal values. It is through these transformative judgments that the law continues to adapt and progress. In this scene, we will explore the factors that contributed to the emergence of judge-made law within the English legal system. We will discuss the flexibility of the common law system, the influence of legal precedents, the impact of social changes, and the role of ambiguity in legislation. One of the significant factors leading to judge-made law is the inherent flexibility of the common law system. Unlike civil law systems, where statutory laws undergoes a lengthy process to effect changes, common law decisions are based on precedent, allowing more flexibility to apply into case decisions. When societal changes occur, judges can review and appeal decisions made in previous cases to formulate a new judgment that responds to the evolving needs of the society. This flexibility enables the common law system to adapt to changes in different circumstances. Legal precedent plays a crucial role in judge-made law. Precedent refers to the previous decisions with similar facts in the same jurisdiction that serve as a reference for judges when making decisions. In the common law system, judges are bound by precedents and are expected to follow decisions made by previous judges. Precedent provides consistency and predictability in the outcomes of similar cases, allowing parties involved to anticipate the likely judgment based on past rulings. The reliance on precedent ensures the protection of citizens' rights and the maintenance of court orders. The law is a reflection of society, and as the society evolves and undergoes changes, judges are compelled to make corresponding modifications to the law. Social norms, beliefs, and values shift over time, often diverging significantly from those of the past. To maintain relevance and regulate the society effectively, judges must adapt the law to the current social development. An example of this is seen in the case of Fitzpatrick versus Sterling Housing Association Ltd. in the year 2000 that I have mentioned earlier on. This decision responded to the societal changes and promoted equity within the legal system. Ambiguity in legislation also contributes to judge-made law. When a case presents a unique circumstances or lacks similar precedents, judges are required to engage in statutory interpretations. They interpret and apply statutes to the case at hand effectively, creating a new precedent for future rulings. Laws can be shaped through the process of interpretation and classifications, allowing judges to fill gaps or clarify the meaning of ambiguous legislation. The flexibility of the common law system, the influence of legal precedent, the impact of social changes, and the role of ambiguity in the legislation all contributed to the emergence of judge-made law. Through these factors, judges actively participated in shaping legal principles and adapting to the law and meet the needs of the changing society. Welcome back, ladies and gentlemen. In this scene, we will explore the factors that contributed to the emergence of judge-made law within the English legal system. We will discuss the flexibility of the common law system, the influence of legal precedents, the impact of social changes, and the role of ambiguity in legislation.
We will now explore the challenges posed by outdated laws, the potential of absurd verdicts, and the need of legal reform within the English legal system. One of the challenges faced by the English legal system is outdated laws. As society progresses and evolves, these laws become ill-suited to the context. Using these laws would definitely lead to absurd verdicts or practical outcomes. When faced with this situation, judges are called upon to exercise their discretion to modify and develop the law in order to reach an outcome that is fair and just. Statutory interpretation plays a crucial role in addressing the challenges posed by outdated laws. When the language of a statute is too broad or ambiguous, judges engage in the process of interpretation in order to determine the statute's meaning. The reasons for needing interpretation was identified by Benyon in Benyon on Statute Law 1990. One of the reasons he listed was the broad terms used when drafting the bill. An example would be if the statute covers laws on vehicle users, there is no clear definition or requirement on what type of vehicle that the law actually applies to. The statutory interpretation would come into play and provide aid by actually allowing the judges to apply the law based on their understanding. When this is done, the true intention of the law does not actually disappear, so technically the law was actually made by the parliament. It was only further developed for them to use it in the circumstances and in the situation. There are several approaches that the judges can take in order to interpret these statutes. The first approach that is expected by judges is the literal approach. This approach functions by the judges using the literal meaning of the statute in their most natural and plain way. For this to be possible, the statute is applied to a case in a way that leaves no room for ambiguity or for further interpretation. Tyndale CJ, the judge in the case of Sussex Peerage case, mentioned that the original wording is the best decision to declare the intention of the lawmaker if it is unambiguous and precise. The case of Magnahart and Earl Cardigan and Cardigan Estates ruled that a block of flats does not fit under the category of a house. Similarly, in the case of Day and Another and Horsebay Limited, it was ruled that a building used for non-residential purpose is also not considered as a house. The statute was clear in defining and stating that a house indeed is just a normal house. There was nothing ambiguous or unclear about it. The second rule, which is the golden rule, is considered to be an extension of the literal rule. When applying the literal rule leads to absurd or inconvenient outcomes, the golden rule will then be used. Lord Blackburn defined the golden rule as justifying, and I quote, the court in putting them in some other signification which, though less proper, is one which the court thinks the word will bear. This essentially means that if the words of the statute has more than one meaning, the court is allowed to apply the one that will lead to the outcome that is not absurd. It involves the process of judges finding what they consider the statute should have provided rather than what it actually provided. In the case of R and Allen, where in Section 57 of the Offences Against the Person Act 1861, the judges used the word marry in the same way of going through a marriage ceremony. The third rule is the mischief rule that assists the judges if the two rules mentioned above fails. The mischief approach looks into the purpose or the aim of the passing of the act in order to determine the meaning of the words that were unclear, which is identified as the mischief to which the statute was directed. This was established in Hayden's case. It sets out 4 factors that needs to be considered while using this rule. The common law before the passing of the act, to identify the mischief in law, the remedy for the mischief, and the reasons for the parliament to adapt the remedy itself. This would mean that the judges would look for gaps or lacuna in the statute law after comparing it with common law and correct it by using the mischief rule and implementing the statutes. The final rule that the judges can refer to is the purposive approach. This approach looks at the reasoning behind the passing of the act. To distinguish it from the mischief rule, the purposive approach analyzes the reason why the parliament wanted to pass this specific act in the first place, whereas the mischief would only look at the purpose of the act itself, as mentioned before. For this approach to be used, the judges would need to refer to the Hansard, as it contains a discussion of the members of parliament, what they had during each day of its sittings of statutes, drafting and enactment.
Despite judge-made law primarily arising from the judicial decisions, statutory interpretations also contribute to the development of judge-made law. Through the frameworks of the statutes provided by the Parliament, it is the judge who essentially put in whole new meaning into it through their interpretations. Therefore, creating a new law also developing the statutes and shaping principles and precedents. The challenges posed by the outdated laws and the potentials for absurd verdict highlights the needs of ongoing legal reforms. It is essential for lawmakers to review and update legislations to ensure their relevance and alignment with societal values. Legal reforms do play a vital role in maintaining a just and fair legal system that responds to the evolving needs of society. Outdated law and the potential for absurd verdict require judges to exercise their discretions and engage in statutory interpretations. Through this process, they can modify and develop the law to achieve fair and just outcome. However, to address this challenge effectively, ongoing legal reforms are necessary to create a legal system that remains responsive and in tune with the changing times.
In this scene, we will explore significant reforms to the English legal system under important judges and their influence. Equity is an essential aspect of the English legal system and played a significant role in property and contract law. It developed as a response to the harshness and inflexibility of common law. Equity offered more flexible remedies administered by the Lord Chancellor and his Court of Chancery. One important figure in this development and systemization of equity was John Scott, 1st Earl of Eldon. Lord Chancellor Eldon served from 1801 to 1827 and focused on codifying and consolidating equity principles. His efforts had a profound impact on the stability and predictability of equity law. Eldon believed in the importance of consistent legal principles and emphasized the application of the doctrine of precedent. First, Eldon created the Consolidated Orders, compiling various equity orders and regulations into a single document. This consolidation made equity law more accessible and understandable for practitioners. Secondly, Eldon introduced the Court of Chancery Regulation Act 1821, which streamlined and modernized the Court of Chancery's procedures, improving efficiency and effectiveness. Moving forward in time, the Judicature Act of 1873 and 1875 reformed the higher court system, which had roots all the way back in the Middle Ages. These acts were drafted by the Judicature Commission, chaired by Lord Chancellor Hatherley. The reform was prompted by the growing significance of industrial, commercial, and financial interests and the need for specialized divisions to handle complex cases. The 1873 Act abolished the higher courts and established a new Supreme Court of Judicature, including the Higher Court of Justice and the Court of Appeal. The High Court was divided into 5 specialist divisional groups, addressing different branches of law. In 1880, further restructuring abolished the common pleas and the exchequer divisions, unifying the system further. The Court of Appeal was established above the High Court, simplifying appeal procedures in civil cases. Additionally, the Appellate Jurisdiction Act of 1876 placed the role of the House of Lords as the highest court of appeal on a proper judicial footing. Lords of Appeal and ordinary experienced judges were appointed to consider and pronounce on appeal cases. Alongside these reforms, the maxims of equity placed a crucial role. Maxims such as "He who must come to equity must come with clean hands," "He who seeks equity must do equity," and "Delay defeats equity," guided the application of equitable principles and emphasized fairness and justice in the courts. The reforms to the English legal system, whether in equity or the court structure, have greatly contributed to the efficiency, accessibility, and fairness of the system. Figures like Lord Chancellor Eldon and the introduction of the Judicature Acts have left a lasting impact on the development and functioning of the legal framework. The recognition of equity, the unification of the courts, and the establishment of specialized divisions have ensured a more coherent and effective legal system for all. In this scene, we will explore the significant influence of Lord Denning, a renowned and influential judge on various areas of law. We'll be delving into his contributions, starting off with contract law. Lord Denning made substantial contributions to the development of contract law through the judgments and decisions made in court. He advocated for a more flexible and equitable approach to contractual interpretation. In the landmark case High Trees, 1947, he introduced the concept of promissory estoppel, which limited the strict application of contractual obligations when one party relied on the other's promise to their detriment. As for tort law, Lord Denning's judgments in cases demonstrated his willingness to expand and adapt the scope of tort liability. He sought to provide remedies for individuals who suffered harm or injustice. In the case of Dottie v. Turner Manufacturing Co., 1964, he broadened the principle of negligence by recognizing a duty of care in a new context, thereby extending liability. Lord Denning's judgments in administrative law cases were instrumental in the development of this branch of law. He emphasized the importance of judicial review in ensuring fairness, accountability, and transparency in the actions of public authorities. His decisions often reflected a desire to protect individual rights and hold government bodies accountable. Lord Denning's judgments in constitutional law cases reflected his belief in an active role for the judiciary and safeguarding constitutional principles and protecting individual rights. He expressed a willingness to depart from established precedents when necessary to uphold justice and rule of law. His approach often involved an expansive interpretation of constitutional provisions to protect fundamental rights. Lord Denning's judgments in equity and trust cases showcased his commitment to ensuring the fairness and promoting equitable principles of the law. He sought to balance the competing interests and rectify injustices through equitable remedies. His decisions often aimed to protect vulnerable parties and prevent unconscionable conduct. Lord Denning's influence extended beyond these specific branches of law. His judgments in legal philosophy, characterized by a commitment to fairness, justice, and social welfare, had a profound impact on the broader legal landscape of the UK. His approach to legal reasoning and his willingness to challenge established principles made him both a controversial and influential figure in British jurisprudence.
That's all for today. I hope you have a better understanding on the judgment law and factors leading to its development, and thank you.